Aloha, this is Professor Porter. We're talking about not only the federal rules of evidence and into hearsay, but definitional hearsay, talking about the exemptions under 801D. This exemption that we're going to cover right here, they sound alike. In 801D1, there's inconsistent statements and there's consistent statements. Inconsistent statements comes up all the time because oftentimes when witnesses testify, they always have statements in the past. They testify inconsistently. It opens up, especially during cross-examination, our ability to get into some of those inconsistencies for the purpose of challenging credibility. But if it meets 801 D1A, it might be that we get them in for the truth, even that prior statement in for the truth. Remember, you can't just go to a witness's prior statements. You can't just go to their deposition testimony. I can't start out with a witness and say, in your deposition, you said objection, hearsay, sustained, right? I have to have a reason for going to that prior statement. And oftentimes the reason is if I testify inconsistently, we can go there to impeach. Prior consistent statements, what I'm talking about here, 801 D1B, is almost always the wrong answer. It's a seldom used rule. It just doesn't come up in the same way. 801 D1C, prior identifications, out of court identifications, also used all the time in criminal cases. So let's talk about prior consistent statements and really what this rule envisions and why it's so seldom what the question's asking. So here's what we see. All of 801D1, we've talked about it in some other videos, 801D1C with out-of-court identifications, 801D1A with respect to prior inconsistent statements, they all come up with these, something has to be going on at trial, this yellow box. They all share the same yellow box. That is, the declarant, the person on the outside who said whatever words we're talking about, is also the witness. The declarant is the witness on the stand. I'm testifying at trial. I'm Porter. I'm testifying at trial, and I'm subject to cross-examination. We got to make sure it's a meaningful cross-examination in the sense that I have to actually have one take place, but it has to be the opportunity to cross. It was a full-blown, I went up and down, direct cross, that type of thing. Prior consistent statements under 801D1B, what we're going to cover here shortly, is really almost, you have to think about it like a redirect exercise. Only really comes up in redirect. And it's tough to ask as a law professor, it's tough to ask a question about redirect because you kind of have to cover direct first with the witness, cross second, and then redirect. But really, it requires on cross-examination, this declarant witness that's on the stand has to be challenged in some way. I have to have something that they've brought up to try to get at my credibility. Basically, in a loose way, I've been accused of lying in some way. So imagine I'm accused of lying and it's connected to a date. That's what you need to use this rule. If I'm accused of lying and it's connected to a date. So I come in here, I'm Porter the witness, and I testify consistently with Pauline, who's the plaintiff, right? And I'm supporting her testimony, and I'm called by Pauline, but I'm also offering testimony that's really favorable to Pauline's case in this plaintiff versus defendant civil action. Well, next thing you know, as part of the cross-examination from the opposing side, from the defense side, part of the cross-examination, they want to explore with me some bias. The idea that Pauline and I have seen each other, the idea that we're dating, the idea that we're in a relationship, and they want to tie that to a certain time. They want to tie that to, I started dating 6 months before this trial in June of this year, and now here we are in December with a trial. They're accusing me of lying. They're accusing me of influence. They're accusing me of bias tied to a specific time. Okay, and that's the, I got accused of lying. So not only am I testifying, not only am I subject to cross, but kind of during that cross, the way this thing has to come up is they connect it to something. So here they say, because I know the plaintiff, because I'm in the relationship with the plaintiff, Pauline, and I got accused on cross-examination. The only time you get into any prior consistent statement, right? Remember, prior inconsistent statements come up anytime it's essentially inconsistent. And then you have some fancy ones that come up when those inconsistent statements are said under oath, penalty of perjury, or at some type of proceeding or deposition under 801 D1A. But 801 D1B consistent statements, I just don't get to bring them up very often. So I'm accused of lying, I'm accused of this bias, and it's connected to a certain date of June of the year, 6 months before this trial. Well, we could introduce a prior consistent statement to rebut that charge of recent fabrication. Awkward language, but really what it means is they're saying that I'm offering this statement today that the car was red that the red car is the one that did it. They're saying that I did this because I'm in this relationship with Pauline. In order to rebut that recent fabrication, I can show that I also said the car was red before June. Before the motivation to lie, I also said the car was red. So just imagine, I don't get to get into consistent statements ever. The idea that I said the same thing and I'm saying here at trial doesn't matter. I could give one prior statement, I could give 53 prior statements. It usually does not matter. Consistent statements, prior consistent statements, have no import. They almost have no impact on trial. We're always having a contemporaneous conversation. But if on cross-examination I'm challenged and it's connected to some date, so look at the problem. Look at the question being asked. Are they saying that there's a charge that you're lying? Are they saying there's a charge of recent fabrication and it's connected to some date like June in my hypothetical? Well, look at the timeline. Was there some prior statement? Was there a statement that was before June where I said the same thing? Because that can go to sort of cut against that cross-examination questions. On redirect, they can say, hey, didn't you say something to the police in February? Objection, hearsay. Your Honor, this is not hearsay defined under 801 D1B. This is a prior consistent statement because the statement to the police is months before the charge of fabrication, the charge of bias in the case where I started a relationship in June. That's all. You get to get into it. And notice, it's not like inconsistent statement. There needs to be no fancy stuff. That prior statement could have been a statement to the police, which might be under penalty of perjury, but there was certainly no proceeding, certainly no deposition. It could be just an email to a friend where I said the car was red, and that predated the June. So really what we're looking for is you need to be challenged in some way on cross. It needs to be connected to some event or date, and then we can only use a consistent statement that's before that to show, no. He's not testifying. He's not lying because of that thing you're accusing him of. Look, he testified consistently to it. Almost always the wrong answer. Seldom comes up, not anywhere near the time that prior inconsistent statements come up. But it is another one that you have to know in addition to out-of-court identification, comes up all the time in criminal cases, and prior inconsistent statements, especially the fancy kinds that happen at depositions and proceedings when the prior testimony is under oath. They come in for the truth, substantive evidence, the truth, and impeachment. This is just something to undercut cross-examination questions.